first, before the Honorable, the Justice of the Appeals Court of Boston, now sitting within qualified law. Draw near, give your attendance, you shall be heard. Boston of the Commonwealth of Massachusetts, this court is now open. Please be seated.
Thank you very much. All right, well, we're here. I'm going to introduce the panel to you. My name is Ariane Vuno. To my right is Justice Sabita Singh, and to my left is Justice John Englander. We've already heard one case this morning on Zoom, and was the case originally scheduled as the fourth case. So now we're going to what would have been the first case on our list, Commonwealth versus George Bradley Jr., case number 2023-0024. Just to remind everybody in the courtroom that you each have 15 minutes to make your argument, that we've read everything that you've submitted to us, so you can get right to your best points, and also to remind you all there is no rebuttal in the appeals court. All that said, Attorney Chambers for Mr. Bradley.
Good morning, Justices. May it please the Court, Richard Chambers, Jr., representing George Bradley, Jr., the appellant. I'm aware that you've already read my brief, so I tried to make 3 points with respect to this matter. This was a case, as you know, out of Essex Superior Court. It was a jury trial. The main charge was an OUI fifth. Mr. Bradley initially had court-appointed counsel. He made a determination at almost 17 months before the trial to hire private counsel to try the case. And during the trial, I made 3 issues. I presented 3 issues before the court. First was, did the trial court err in determining that Bradley's failure to submit an affidavit of trial counsel was fatal? And what I argue in my brief and what I say is, in this case, it was pretty obvious, I would say, on the record that the trial judge admonished trial counsel for not being prepared. There were some major issues. I'm stepping back a little bit, but I think the strongest issue was that the opening statement made by defense counsel prejudiced Mr. Bradley greatly.
And that's a situation that unfortunately comes up, I won't say frequently, but has come up before, and our cases have addressed that issue when defense counsel perhaps inappropriately, but not necessarily unreasonably, tells the jury that someone is going to come testify, or says that there's no one going to be testifying on a certain issue, as what happened in this case. And we've consistently said that's part of the trial strategy, and that's not necessarily, does not necessarily even meet the first prong of Safarian, let alone the second prong.
Well, my argument is that obviously that was manifestly unreasonable. A promise made in opening is more damaging to promise something and then not deliver.
It's never good. Anyone who's been in front of a jury knows that's not a good thing, but we don't look at it in terms of whether it's good, bad, prudent, imprudent, appropriate, or inappropriate. We look at it as determine whether or not it was a reasonable tactic under the circumstances. And you have to say, in this case, really nobody expected Ms. Harmon to appear and testify.
Well, I would disagree in that point, Judge, because what the trial judge pointed out to trial counsel was, look, there was a pretrial conference. Her name was on the list. You've had a lot of time to prepare for her. And I believe that it is, I've tried many jury cases where there's a chance that the alleged victim or the main person isn't going to show up, but I still prepare based on the fact that they're going to show up. And I think here, where the district attorney, assistant district attorney, says to defense counsel, if I was a betting man, I bet she wouldn't show. Well, he should have been prepared for her to show.
But
and
is
making
it
a promise
manifestly unreasonable? I mean, what he has in his pocket is that someone sitting in the car is going to say, I was there the whole time and he didn't have anything to drink. So he's trying to emphasize that witness, and he thinks there's going to be no witness to contradict that. Is it manifestly unreasonable, below the standard that we would expect of an ordinarily fallible lawyer to take that chance?
I think it is, because when he says, if I was a betting man, you're making a bet. Defense counsel is rolling the dice.
That's what the prosecutor said. But we don't have an affidavit from the defense lawyer saying I was making a bet. What we have is the judge's view of what was and was not manifestly unreasonable under the circumstances, right? Is that entitled to deference?
Well, I would say here, Your Honor, there's another, it goes beyond that, because although we don't have an affidavit, and we did reach out to him, but the problem is that...
Did you say, is that in there anywhere, that there was efforts that were made to obtain an affidavit?
No, Your Honor, because defense counsel didn't want to do it. He didn't want to talk to it.
Usually or often we see an affidavit from appellate counsel saying attempts were made and not successful. And when that happens, that does put things in a fairly different perspective. So if it's not in an affidavit, I appreciate your telling us, but we can't really rely on that.
No, I understand that, Your
Okay.
Honor. But I would say that it goes beyond that, because on the record, the trial judge says to defense counsel when he wants to impeach this witness with prior record, she admonishes him again for not being prepared, not knowing the law with respect to impeachment.
Okay, but that's a different point, all right? So maybe we can keep them separate. I was asking about whether it was manifestly unreasonable to make the decision that he was going to highlight to the jury in opening, no one is going to come in here and say that they saw him drinking.
I believe it is, Your Honor, because you're making a promise to the jury, and it goes to intoxication, and that really was the strongest part of the defense from a strategic point of view, because there are witnesses that put Mr. Bradley behind the wheel. There are other witnesses, but you got Ms. Harmon that initially at the scenes makes a statement that the ammunition was hers. So again, he's taking a big chance, a risk, with making a promise, and then when she does take the stand, that promise, you lose credibility. You immediately lose credibility with the jury, and you lose credibility that you can never get back.
Well, let me take this to a different level, which the judge addressed, and addressed actually quite emphatically, and that is even accepting your position, which is you bring up 3 or 4 different areas in which you believe that counsel was conduct was not was subpar, let's say. In the end, the evidence was very, very strong, right? So when you still have to show prejudice, and the judge here who presided over the trial in a lengthy memorandum of decision, written decision, decided that you could not meet your burden on showing prejudice. You want to address that for us?
Well, I'd like to address the strategy behind or making the statement that he did, because strategically, as defense counsel, he could have reserved his right to make an opening statement and saw what the evidence was going to be before making a promise, right? And he didn't do that. So strategically, I'd say it is manifestly unreasonable making a promise when you're defense counsel, when you have an option to.
But where's the prejudice? What other, where did you lose another substantial defense in this case?
Well, I think you lose like I said, you lose your credibility.
There was a terrible accident.
And you can't unring that bell with the jury. You made a promise to the jury, and you can't unring that bell. So you lose, once the jury hears.
I'm hearing that you're ignoring the prejudice prong a little bit.
I'm not ignoring it, Your Honor. I think.
So what other substantial defense was not presented, or what could have been presented, but for counsel's alleged conduct in this case?
Well, I think that when the witness took the stand, Ms. Harmon, she could have been effectively cross-examined in a different way, because the promise was made, you're not going to hear anything about.
And what would that how would that have benefited the defendant?
It could have been with respect to the fact that she changed her story from the beginning. She said the ammunition was hers. So are you lying then, or are you lying now? That when he made his opening to the jury, he could have said a lot of things. There's a presumption of innocence. You're going to hear evidence. And I think the prejudice is the fact that, again, once he made that statement, he couldn't unring that bell. And he could have said a lot of different things in his opening, but the prejudice was that he was unprepared for that witness.
Okay.
But wait a second.
Go ahead.
Just saying he's unprepared doesn't answer the question of prejudice. If he were prepared, what would have happened differently is the question of prejudice.
Well,
What did his client lose because of his lack of preparedness?
Well, the client lost, I believe, the ability to recover with the jury made on that. I keep going back to that promise, making a promise to the jury that you can't unring that bell. So the prejudice was, first of all, he was unprepared with respect to, again, impeaching error and prior convictions.
The jury doesn't know that, right? And so what could he have done better on the impeachment front? Because as I read it, the answer to that is not much, really. At least on the question of other crimes, he either gets it in or he doesn't. He got in what he could, right?
Well, no, because he believed he could have treated her as a hostile witness. He could have had motions in limine. He could have been prepared for the fact that she was going to come in and testified the opposite way. He could have talked about what inducements she was given to change her testimony. There's a lot of things. He could have filed motions in limine.
He tried to go down that road, right? I mean, he asked whether she'd been told that her children would be taken away.
He did try to go down that road, Your Honor, but I think that, again, once the jury was made a promise as there was going to be no testimony with respect to intoxication, you can't unring that bell. The jury heard it.
Well, no, what he said was there's not going to be any witness who actually saw him drinking. There was plenty of evidence of intoxication because the officers described what he was like when they approached him.
Well, there was no evidence. They did an inventory search, and there was no evidence of
But let's
alcohol.
not ignore the fact that he couldn't even get out. He couldn't stand up straight. He was unstaying his feet. His eyes were bloodshot, and there was a strong odor of alcohol. So there was evidence of intoxication in the case.
Well, I would say Miss Harmon was the linchpin. She was the one that said, I was with him from Maine. I was in the car. He was drinking heavily. She was the person that the jury relied on more as a neutral person. In fact, even more prejudicial because she was in the car with him and a friend and an ex-girlfriend. They had a relationship. And it wasn't like it was coming from government witnesses, police officers.
But there were other third-party witnesses, right, who weren't government witnesses?
There was no third-party witnesses, Your Honor, that were in the car with him from the beginning, coming from Maine.
Ones that he almost ran over or did run over.
Well, there were civilian witnesses, Your Honor, but, I mean, they couldn't testify from direct observation whether or not he had been drinking prior. It could have been a number of reasons that he almost ran them over, accidentally or whatever.
Right?
So, is there anything else, Your Honors, would like to ask me?
No further questions. Your points are well taken. Thank you very much.
And I'll defer the rest of my time and rest of my brief.
Okay, fine.
Thank you.
All right, thank you. We'll hear from the Commonwealth now.
Good morning. May it please the Court. David O'Sullivan for the Commonwealth. I was not the attorney on the brief. To begin
Well,
with...
do you think if this defendant had somebody else, like the person sitting right here at council table, things would have been a little bit different for him?
I don't.
It's been better.
I don't, and that's not a hit on Mr. Chambers' considerable abilities in the courtroom. But I don't think, for some of the reasons that were reflected in the panel's questioning, that it would have made a difference. There was an admonishment to counsel for his lack of preparation in the event that Harmon did appear, and that was legitimate admonishment. But as Justice Englander mentioned, the focus is on actual performance and whether better performance could have actually achieved something for the defendant here. And there's nothing with respect to impeachment of Harmon that the defendant points to on appeal.
Can we just switch for a moment? We'll get to impeachment in a moment, but are there cases that tell us that we need to defer? And if so, what do they say? With respect to the judge's finding, not manifestly unreasonable under the circumstances, which I think the judge did find.
Correct. And yes, there are. This court's 2021 opinion in SIN, S-I-N, makes that point that there is deference to the judge's finding that A, it was a strategic decision, and B, that it was not manifestly unreasonable. That decision is, of course, assessed based on whatever information counsel had at the moment. That's the key sort of way.
But So as an appellate court, there's a legal standard here, it seems to me, or at least a question of law as to what is manifestly unreasonable behavior of counsel, right? Mm-hmm. Clearly, counsel made a mistake looking backwards, if you will. In hindsight, never should have said that, right? But don't we know, maybe we don't know all the circumstances because there's no affidavit from defense counsel. In other words, there's a question, was it manifestly unreasonable under all the circumstances at the time the trial counsel made that decision, right? That, it seems to me that's got to be the question. And if that's the question, is the trial judge in a better position than us to make that assessment?
Well, it's a tough question because there is a question of law there and there is a question of fact there essentially, and the judge's assessment of counsel's performance at trial is owed some deference. His or her evaluation of witnesses at a motion for new trial hearing is entitled to some very strong deference. And this court's statement in SIN is that even the determination of law that it wasn't manifestly unreasonable to act in that way is entitled to some deference. And I would suggest maybe a way to think about that would be that it's the same deference. The court's assessment of any denial of a motion for new trial is done not for error, but rather for abuse of discretion. And so I don't have
Okay.
I don't have a better answer than that, Your Honor, but it's a good question.
I think it's a good answer, counsel.
With respect to the opening, I don't think it's a fair characterization. While obviously the court's cases, as the panel made clear in its questions, focus on the fact that openings are inherently predictive. That's what they are. That's what the judge instructs and instructed here that they are. I
don't know if I saw it in the briefs, but I assume the judge gave the usual instruction, this is not evidence.
Yeah.
She did, yes. She is not evidence, and also it's a forecast of what the attorneys expect the evidence to be. When defense counsel rolls the dice and makes such a predictive statement, if they turn out to be wrong, either in evidence that was promised and didn't materialize, or evidence as here that was promised wasn't going to materialize and in fact did, we evaluate whether it was manifestly unreasonable based on what defense counsel knew at the time. And here, defense counsel knew what the prosecutor knew, was that this person was from Maine. She had been uncommunicative with the Commonwealth, and also that she was subject to arrest when she came across the border to Massachusetts for that larceny complaint. And so the prosecutor's good faith prediction was that if he were a betting man, she would not show up. That turned out to be wrong. But the question is, as to prejudice, we look to not what Harmon testified to, but rather the hit on counsel's credibility in making that predictive judgment that proved false. Was that so bad that it requires a new trial? And I would suggest for 4 reasons it wasn't. First of all, the defense was not structured. It was a feature of the defense that Harmon wasn't going to show up as predicted in the opening, but it's not fair to say that the defense was structured around her absence. The defense was one of accident, an accidental caused by admittedly aggressive driving. It was the defendant's injury. It was the lack of corroboration through evidence in the truck of actual alcohol consumption. It was a lack of corroboration through video that the defendant, including video at the station, which we would think would be readily available.
Doesn't that all fall under the category of, hey, no one's going to say that no one is going to prove to you that this person was drinking.
Well, you could still focus on the things that I just mentioned if she doesn't show up. And he folded that, I would say, very nicely into,
Yeah, you
she's
could-
not credible.
could focus on it if she doesn't show up, but if she does show up and says, I was sitting right next to him and he was drinking alcohol the whole day, that hurts the defense.
What's left to counsel is what defense counsel said, which is that ultimately there was no corroboration of her story of Dr. McGillicuddy's in the car when there are no bottles in the car.
And she's a liar. We know she's a liar because she said something to the police at the scene that's directly contrary to what she's saying now. But he didn't do a very good job of cross-examining on that, did he?
Well, he did mention her prior inconsistent statement and argue in closing that it made her not credible. And he also...
You know, I read the cross and I didn't see where he said, you told the police at the scene that you were asleep the entire time and heard nothing. Maybe I missed it.
I believe it is in there, and it is in the closing that she made that prior inconsistent statement that she had been sleeping. But also with respect to that impeachment, and again, we're focusing on the actual performance here, the judge, I would submit, properly excluded the larceny charge because there was no evidence that she had changed and become more favorable in her account to the Commonwealth after that charge. Despite that, defense counsel got it in and apparently misunderstood the judge's ruling on that and got in the fact that she had been charged with larceny, and that was a feature of the defense. So he was given a boon, essentially, that other counsel may not have been able to avail themselves.
But she also said she didn't know about it until she arrived.
Yeah, that's true. That's true. And so, but it was there that
Lowers that
she
boon a
was
little
she was charged by the same office that was charging Mr. Bradley. I would like to comment, if I could, and obviously the court is aware that there was overwhelming evidence here, or that's my characterization, not yours. There was substantial evidence, apart, even taking Harmon's testimony out of the equation. There was erratic operation that was extremely erratic operation and aggressive driving testified to by civilian witnesses. There was his extremely slurred speech at the scene and his spitting while he spoke. There was his alcoholic breath, his bloodshot eyes, his argumentativeness and combativeness later on, his dismal performance on the field sobriety tests. He could not get past C in the alphabet, and after that made only unintelligible noises despite multiple tries, and his finger dexterity test was similarly unsuccessful. And there were officers on the scene. Officer Dowd opined that he was drunk, and Sergeant Harkins opined that he was hammered. So I would submit that even taking Harmon's testimony out of the picture, there was overwhelming evidence just there. But when you add Harmon's testimony to it, it is truly overwhelming evidence. Also, if I could just comment in closing, unless there are further other questions, there's an insinuation in the brief that the prosecutor was engaging in some gamesmanship. And that insinuation, I think, is disturbing because it's not supported. And I would just point out a point that was not made in the brief, that there would be some, a readily expected source for information that would counteract the prosecutor's, statement in good faith that I don't think she's going to show up. Harmon would have been the person to say, no, I called him the day before the trial and said I was showing up. None of that, and Harmon's affidavit is in the supplemental record appendix. There's no such statement that would contradict the idea that he was not engaging in gamesmanship. So unless there are further questions, I'd rest on the brief.
I'll check. No further questions. Thank you both very much. We'll take the case under advisement. Next case on our list is Commonwealth versus Frederick Pinney, 2023-0772. Good morning, Counselor.
Good morning, Your Honors. Luke Roseal for Frederick Pinney, and may it please the Court. The issue before the Court today is really whether Mr. Pinney will be able to maintain any hope of getting meaningful relief by way of his direct appeal. Mr. Pinney has already served more than 7 years of his 9 to 10-year involuntary manslaughter sentence. His is a complex case with a voluminous record, several interlocutory appeals already. And so the likelihood that his direct appeal would be resolved before the incarceratory portion of his sentence is finished is very low, absent a stay of execution of sentence. And a stay of execution of sentence is appropriate in this case because Mr. Pinney did show that he is not a flight or security risk, and he did show that he has at least one meritorious appellate issue. But before getting to the substance of those arguments, I want to address the Commonwealth's waiver argument, if it please the Court.
Well, let's just get right to the substance because we will be likely addressing all the issues.
Thank you, Justice.
I want to frame it slightly differently, if I may. Isn't the issue before us whether or not the single justice of this court abuses discretion in affirming the denial of the order staying the execution of sentence?
I think that's a correct statement of the standard of review under Nash.
Okay.
But if you stop the statement there, the listener would have no way of knowing abused his discretion with respect to what, right? And so I would say the substance of the issue does come...
Respect to the independent review of whether or not there's A, a meritorious issue, and B, whether or not your client presents a security risk.
Precisely, and I think that is
In this case, I believe the single justice pretty much relied on the second prong of security risk. Would that be fair to say?
Exclusively relied on that second prong, Your Honor. Yes, Justice Fuono. And so that is correct, and I can see that under Nash, this court reviews the single justice's decision for an abuse of discretion, and the single justice did abuse his discretion in upholding the trial court's decision for several reasons. And I'll start with the security factor because that's the one that the single justice focused on. And I think there's really kind of two groups of reasons I want to focus on here. The first is the history of success that Mr. Pinney had on pretrial release, and the second is his medical condition and the extent to which that impacts his being a security risk or a flight risk. And so with that history of success, I think the evidence at trial was clear that this crime was committed while Mr. Pinney was in the throes of substance abuse disorder. And when he was arrested and incarcerated pretrial, Mr. Pinney did sober up. He was a model detainee for those 7 years of pretrial detention where he worked within the jail, cleaning and doing other jobs in sensitive areas. When he got his release for those 2 years, he worked self-employed, never a single blip. I think it's notable that if you look at the chronology notes that are in the impounded record appendix from probation, no suggestion of Mr. Pinney ever taking liberties, no suggestion of probation officer Sandillo ever letting anything slide. I think it's absolutely clear that Mr. Pinney was a model releasee during those 2 years. And the case I want to emphasize...
Judge Callan didn't think it was absolutely clear.
I think from Judge Callan's decision, what we can glean from that decision is that Judge Callan very much disagreed with the conditions of release that Judge McDonough had allowed pretrial.
And was concerned that because there wasn't face-to-face meetings, that it wasn't crystal clear, right?
I think that was his concern as expressed with the strong disapproval of the lack of face-to-face
ordinarily,
meetings.
a murder, someone accused of murder would not be in a position of not having face-to-face regular meetings with their probation or their parole, what is it? I'm sorry.
With the probation officer monitoring the pretrial release. Yes, and I think what we see from probation officer Sandillo's testimony is that Mr. Pinney was not an ordinary murder one defendant. It's not ordinary, certainly, that a murder one defendant would be held 7 years pretrial. It happens, but we hope that the case is resolved before that time.
Well, he was tried once, right? That was part of the problem.
That's correct. Yes, he was mistried once. Yeah. It's out of the ordinary that he'd be able to maintain gainful employment as a self-employed contractor. There were face-to-face meetings in the form of weekly Zoom meetings, which of course have become much more common in the post-pandemic world.
But there's no way during Zoom to be able to, probation officer to be able to assess whether the person is under the influence. I mean, it's much more difficult to do that
I would say so, and I think it's true, you know, in proceedings, whether it be before this court or the trial court. Certainly my strong preference is to do them in person for any number of reasons. But where Mr. Pinney did have deep ties in the community where he's from in Connecticut, and I want to recognize the presence of his family here, his fiancee, trial attorney Linda Thompson, who's also here, where he did have those community ties, and where you did have a very experienced probation officer in the person of Mr. Sandillo, who's been on the job for over a decade, hundreds of supervisees, said Mr. Pinney was among the best releasees that he had ever supervised. They're checking in each week on the video, and Mr. Pinney showing him the job site week to week. Just the notion that...
That was in Connecticut, right?
That's correct, yes. And I think at least one of the jobs may have been in Massachusetts, which is the one that P.O. Sandillo happened to be near and actually did come on the job site.
Accepting everything you say, I have a difficulty squaring it with a trial judge who saw Sandillo testify and doesn't give the same level of deference that you indicate we ought give. And in fact, at one point at least suggests he's not buying what Sandillo has to say.
But Justice Inglater, I would push back because Judge Callan did nothing more than to make that suggestion. I'd be in a different position right now if Judge Callan said, I do not credit Probation Officer Sandillo's testimony. But I think Judge Callan had to recognize Probation Officer Sandillo had a very strong incentive to tell the truth, over and above the normal incentive under the pains and penalties of perjury when a person takes that oath.
Yeah, I agree. I don't think he suggested that the officer was not telling the truth. And I think he gave his reasons as to, characterizing, he gave his reasons that the supervision wasn't intensive enough for him to be able to give this characterization of the defendant being this model probationer. Because the review wasn't intensive enough. So it wasn't a matter of saying, I don't believe what the probation officer is saying, but his testimony has less value to me because he didn't give an intensive review.
Well, I think Probation Officer Sandillo did testify that among all of the releasees he's had, Mr. Pinney was among the best, the most compliant throughout Probation Officer Sandillo's whole tenure. And I think I want to try and put this into a little bit of context going back to December 2022, because it was then when trial counsel had filed a motion for findings of fact and conclusions of law on the motion to suppress the court-ordered buccal swab. And at that time, it was before Judge McDonough. And Judge McDonough issued a stay in the case to allow for an interlocutory appeal to proceed under Rule 15. And then, this is not in the record appendix, but it's in the record. It's docket item number 275, a February 13th, 2023 motion to recuse, which contains a press release from the District Attorney's Office on January 12th, 2023, where the District Attorney's Office told the press that the defendant's release is an injustice and an insult to the tenets of our criminal justice system, among other things. That's January 12th in conjunction with a media junket that the alleged victim's family had put on. The very next day, Judge Callan decides to take over the case as the Raj, orders the parties into court the following week, and vacates the stay and sets it for trial the very next month. So I think that really shows that Judge Callan took great issue with the extent of supervision that Judge McDonough had permitted. But Judge Callan's gripes, although whether or not they have merit with that extent of supervision, are irrelevant to the question of whether the evidence in the record gave Judge Callan, and by extension the single justice, discretion to say that Mr. Pinney was a security risk or a flight risk. And the case
changed status.
Yes, he did change status where now he's convicted, but that cuts both ways, because pre-trial he had the prospect of a life sentence without the possibility of parole. That's no longer hanging over his head. I also understand he doesn't have his presumption of innocence any longer, and that makes a difference, but that at least cuts in both directions.
So I'm clear, when you say it cuts in both directions, your point being that he only has under 2 years to serve.
Correct. And the case I want to emphasize on this point really is
I'll throw you another softball, if I may, because I'll be asking your counsel about this. When we talk about lax supervision, if you will, allegedly lax supervision, is that partly also because there was no problem?
I think that's exactly right. There was no request from the Commonwealth to have more stringent conditions. There was no reason ever that arose for more stringent conditions. And I think
So I am correct, there was no problems arose during this period of time.
That's exactly correct. That's exactly correct. And the case I do want to try and emphasize on this point is Nash, because as in Nash, The facts favoring release, quote, "do not feature significantly, if at all, in the trial courts or the single justices by extension assessment of the second factor. Judge Callan, quote, appears not to have given much weight to several other facts that go into the mix of security factors. Mr. Pinney had virtually, quote, no prior criminal history, no other impropriety of any kind. Offenses were out of character, completely inconsistent with his history. Deep roots in the community, I think, as is illustrated by the members in the gallery here today.
Of course, in the community, not necessarily Massachusetts.
That's correct, the community into which he's seeking release. And so Nash was an instance
Which is highly unusual, that someone who has been convicted of murder and has a motion to stay based on an appellate argument that they say is strong would be released to another state, right? That sounds highly unusual.
Well, I think, and I think the facts of this case are highly unusual in that he has those deep community roots in that state. He's got a potential for employment, but given his medical condition, also has the medical care he would need there. And it's highly unusual to
Help
have
us
the 2
out,
years.
how far away are we talking about? Because Springfield is 15 miles away from the
That's right.
border.
I think it would be approximately, I'd have to look at it more carefully, but approximately equidistant from Springfield to here as it would be Springfield to the location where he would.
Okay, so it's in somewhere inside Connecticut, not just over the border, it's further in. I get it, okay.
And
Can I ask, in your brief, you suggest that the Commonwealth did not really object to the proposed conditions of release that were argued for. What did the Commonwealth say, and where will we find it?
the Commonwealth, it's in the transcript, and I do make the transcript reference in my brief. I don't have it right in front of me, but the Commonwealth's position expressed to the trial court was there should be no stay because there's a weak legal issue. But if there is a stay, that we largely agree with the defendant's proposed conditions, except we'd like GPS, which shows that GPS would be practicable down in Connecticut, and we'd like a stay-away order from the victim's family, with which Mr. Pinney is perfectly amenable to the stay-away order. He'd object to the GPS on Fourth Amendment grounds, but certainly would be far
Find that in the
preferable.
transcript of the hearing before Judge Callan.
Correct, and with leave of court, I can submit a
That's
letter.
all right, we can find that. Okay. Can we just switch, because although our single justice did not rely on the legal issue presented, we can affirm on any ground in the record. Why aren't we talking about inevitable discovery here? I take it your position is because a Miranda error occurred that the DNA of the defendant is forever lost to the people of the Commonwealth.
I would say that's incorrect, Justice
Okay.
Engler,
Help
for a
me
couple
then.
reasons. So let me start with the independent source question. The reason why we're not talking about independent source is because this court ruled it out in its prior...
Yeah, I'm not. I'm talking about inevitable discovery.
Yes,
The
yes,
two
yes, I'm
are-
sorry, I
the-
misspoke.
The two are often confused,
Yes.
and Justice Scalia explained some of this in the Murray case. But my point is inevitable discovery.
And so let me speak...
How are they not, as police officers, going to ask for the person's DNA when that person is in the home with a victim who is found in his bedroom dead? How are they not going to ask for his DNA?
Certainly. So the inevitable discovery question has to be evaluated from the point of view of the facts as they existed at the time when the illegal discovery was made. And that
I just
argument...
gave you the facts.
Yes.
Every one of those facts has nothing to do with any investigation of the defendant,
And every one of those facts was before this court in its last Pinney decision.
which they said hasn't been proved yet. That's all we said.
Well, that's
You
because...
can go back.
Well, what this court said is it ruled out inevitable discovery and said on the record before...
Did not rule out inevitable discovery, counsel. I've read it 3 times. They said has not been proved, but you can go back.
Well, what they said, but you can go back, was on the independent source question. They could go back and seek another buccal swab using probable cause that came from an independent source. But I think we have to look at the inevitable discovery question from the point of view of...
Can we just stop on?
Certainly.
You're convinced that our opinion rules out inevitable discovery. What part of that opinion are you relying on? What language?
The quotation, I think it's at page 402, is the record before the judge at the time did not support a conclusion that discovery of the buccal swab was certain as a practical matter. So when the defendant moved to suppress the buccal swab, it was then for the Commonwealth to create a record that the buccal swab would have been inevitably discovered. This court said the Commonwealth failed to create that record at the relevant point in time. And so the court sent it back, and the court also said attenuation is not on the table, but dropped a footnote and said you could use independent probable cause, didn't look at the subjective prong in Pearson. And so if I might have just one moment, maybe 1 minute to say two other things, if the court would indulge. So the first is on this subjective prong of Pearson. The relevant point in time is when the Commonwealth made its decision to seek a second swab. We know that was November 2018 because the Commonwealth submitted a memorandum saying we've decided to seek a second swab, and what prompted us to make that decision is the illegally gained information we got from the first swab. So I really want to emphasize that the relevant point in time for inevitable discovery is when the original motion to suppress was wrongfully denied. The relevant time for the subjective inquiry under the Pearson prong is when the Commonwealth made that decision. The last thing I would say is...
Really fast.
Yes, thank you, Your Honor. Is just on the... at the briefing stage, medical parole was ongoing. This court can take judicial notice that medical parole now has been denied by the Commissioner. And so medical parole, we may take an appeal on that, but it's a related matter, so I think you can take judicial notice it has been denied. Thank you, Your Honor.
Thank you very much for your argument. Don't worry, Counselor. I'm sure you know it now.
Just fighting with the page, Your Honor. Good morning. May it please the Court. ADA William Joyce on behalf of the Commonwealth. I don't actually have that much to discuss, so I'd like to start with the question.
Let me give you it was a softball for your brother and a hardball for you, and that is the following. When there is no issue with the probationer, when nothing arises, how is it that we can say that we can't evaluate the conduct of the probationer because the supervision was too lax?
Well, I think based upon the facts of this particular instance, Your Honor, if I may in a kind of meandering way answer this question because it's going to have multi-parts. Going back to the testimony of Mr. Sandillo, he stated that he had only previously supervised 2 out-of-state probationers before. So most of his experience is supervising people in Massachusetts. Now, he stated that he didn't foresee any sort of logistical issues with supervising someone out of state, but at the same time, he didn't know he didn't know what the process would be to, if this out-of-state probationer violated the terms of his release, what would happen other than, I just go talk to the DA's office. So there's a suggestion that he's relatively inexperienced in the circumstances of the defendant's release. Additionally, if I may just turn to the exact conditions.
Is it pretty evident that if there had been a violation of the conditions, or particularly if a new crime had been committed, that he would be arrested or brought in?
Not necessarily, Your Honor. If I may turn to the exact conditions of the defendant's release, they were modified a number of times, I believe approximately 4 times. But on page 16 of the Commonwealth's 15 and 16, it outlines sort of this timeline of the modifications. But ultimately, at the time of the defendant's trial and ultimately his conviction, his conditions were more or less, pardon me while I find the right page, or find the right sentence here. Oh, my apologies. It actually starts on page 13. Initially, he was released on $100,000 bail. Additionally, to abide by the following conditions, reside with his niece in Vernon, Connecticut, sign a waiver of rendition, a 0 curfew except for medical or court-related reasons, undergo a mental health and substance abuse assessment.
What does 0 curfew mean?
My understanding is he is not to leave his residence
Except for particular reasons.
except for medical or court-related reasons. Now,
but that had to be modified so he could start working.
yes, that was later modified to allow, probation was given discretion over his work hours and location. That was the later modifications. This is the initial conditions. My apologies if that was unclear. He was also directed to sign all releases requested by probation, or provide verification as directed by probation, report to probation once a week by telephone or as directed, and refrain from using illegal drugs. That was later modified, as Your Honor pointed out, reducing the zero curfew, allowing probation discretion regarding his work hours and location. Additionally, there were a couple modifications changing his residence. The defendant moved out from his niece's residence.
Is your brother accurately representing the statements that the Commonwealth made during the hearing before Judge Callan to the effect that the only changes to release conditions that they would propose were, one, that there be a GPS, and I'm forgetting the second one at the moment. But
More or less, Your Honor. I believe what was actually stated
So the
was-
arguments you're making now are in support of the findings of Judge Callan, but they're different than the position that you took before him.
Not
Is that right?
necessarily. The Commonwealth's position was that the defendant should not be released. But if Judge Callan, I'm giving him a promotion, did determine that the defendant should be released, because the defendant is seeking to reside out of state, there is only so much that the Commonwealth can request. A GPS is one of those things, and I think that's a big difference.
Well, but what's missing, and it seems to me to be the elephant in the room, is a condition that says he can be released, but he has to stay in Massachusetts, because I'm very concerned about him being outside of Massachusetts.
I'm unclear if that's something the judge could allow, given that the defendant is indigent.
The condition of release under, I mean, how can it not be within the judge's discretion to impose the condition that I might be willing to release him, but he has to stay in the state?
Well, my point is, given that the defendant is
No,
indigent.
just answer my question.
Yeah, answer the question, because following up on Justice Ingler's point, it's hard to believe that given the counsel that he has, that they couldn't have had help finding him a place to live in Massachusetts and work in Massachusetts, if that was so important.
The judge could have made that condition, Your Honor. He didn't. He determined the defendant should not be released.
And the
instead.
Commonwealth didn't ask for it either.
This is correct. But at the time, it wasn't obvious that that was something we could ask for, Your Honor. I'll be completely honest. Had I known that was an option, I would have asked for it.
Well, I
But as
wasn't standing in your shoes. It might not have been the best one because, of course, as it turns out, there was a stable place to live and work in Connecticut.
in Connecticut, right. That's the thing, that all of the defendant's requests are in Connecticut. He has never asked to live in Massachusetts. I believe initially, I apologize if I am misstating the record on this point, I'm going off memory, but I believe initially the Commonwealth did object to his release to Connecticut, but once he was allowed to live there, it was kind of fighting the inevitable almost, given the way the various modifications had gone. Again, I'm working off memory, and that might be faulty.
Well, but you would agree that the entire time he was in Connecticut, there were no issues in terms of...
No issues that we're aware of, Your Honor. Again,
Which equates to no issues.
I suppose that's one way to look at it.
How hard is it really? Can you educate us on this? I mean, the DA's office is in Springfield, Connecticut border is close by, people go back and forth, they work. Is it so difficult for somebody in the probation department in Springfield to be able to oversee somebody who's living out of state? Isn't there a relationship between a DA's office or probation office in a neighboring state with Springfield?
I would assume so, Your Honor, but I cannot say with certainty. It would certainly make sense. But there's no indication that there was any sort of communication between the Massachusetts probation and Connecticut probation offices. And that is one of the things, the points that goes back to Mr. Sandillo's inexperience in this area, that it's unclear if he even knew he could liaison with the probation officer out of state.
Do you think that the legal issue that they are raising is sufficient under Nash?
No, Your Honor. Short answer. I can expound upon that if you wish.
Yeah.
This is a very, not so much complicated, but convoluted issue. I believe Justice Callan, I'm sorry, I'm doing that again, my apologies. Judge Callan.
It's all right. I think actually that is.
Matter.
I believe Judge Callan summarized the arguments best on this point of the defendant has never stated or never argued that the Commonwealth lacked probable cause to seek that 2020 buccal swab. This was a murder case. There were only a limited pool of suspects. At the time the police arrived, it was the defendant, the victim, and the victim's boyfriend that were present in the house. There was blood on the scene. This was something that we were always going to get a DNA swab from all participants. And as the court has pointed out, the Supreme Judicial Court has pointed out, the idea is not to punish the Commonwealth.
Was this argument made?
I mean,
One of the things, I'm sorry.
no, go ahead.
No, and one of the things that I have difficulty with is I understand the argument of inevitable discovery, but our court said it hasn't been shown yet. I guess I need to go back and look at the record of what was said in the prior suppression hearings way back when.
My apologies, Your Honor. If you could slightly rephrase, I think you lost me a bit there.
Yeah, well, I'm sure I have, and it's my fault. But here's the point. Inevitable discovery could have been argued in the original suppression motions that led to the appeal where the buccal swab was originally suppressed. And I'm kind of asking the question, how was that issue litigated that led to our court saying, it hasn't been proved, but you can go back and do it again?
Again, I'm working off memory here. That was before I joined the case, so I believe at the time the argument was that we were permitted to take the swab because it was part of an interview that we believed was valid.
So you're saying the inevitable discovery argument may not have been made at all?
I don't believe
Because you were focused on the fact that there was no violation of Miranda.
I do not recall if that crossed the mind of anyone
Okay.
on the Commonwealth's end
Thank
at
you.
the time.
But then now, we've argued here that, that there was never any disagreement of whether there was probable cause to procure a DNA sample. But that's not really the issue here, right? There may be probable cause. The point is that an independent source doctrine, you can't rely on any information that you obtained as a result of the illegal conduct.
Correct. And
And in your application for the second swab, the way I read all of the exhibits there, and please correct me if I'm wrong, the DNA results from the first swab are right there. And one would assume them being relied upon in order to obtain this second sample.
not exactly, Your Honor. The results specific to the defendant, I believe, were redacted out. They were basically covered over with
They
Sharpie.
were.
The other results are from the victim, Miss Moore, and the boyfriend, and some other evidence that was recovered. What we were testing was basically...
So in other words, when I reviewed that application, I was incorrect. You're saying that the application that actually was submitted in support of the second sample did not include
Correct.
the results of the, okay.
In 2020. Nor
All right.
did it rely on
But it
any
did in
information.
2018.
Pardon me?
But it did in 2018.
2018 was before this court's decision.
Thereafter.
Never acted
I
on.
see, okay.
And I will also state that the application did not rely on any of the information suppressed from the defendant's interview that this court also suppressed.
So the defendant in their papers indicates that the Commonwealth at some point stated that they were motivated to seek an order for the second swab because of the result of the first swab. Do you agree with that characterization?
I do not. If we're talking about
Is the motivation, Commonwealth's motivation relevant?
If we're talking about the 2018 memo, I believe the theory behind that was there was some concern that we may lose the initial buccal swab. So the motion in 2018 was filed to kind of cover our bases. That was never acted upon, and then this court's decision came out and it became moot.
There is a statement that I saw, because in 2018, there is reference to the DNA results at
Correct.
length. But then the Commonwealth would ask this court to make a specific finding that the buccal swab requested by the Commonwealth herein is derived from an independent probable cause determination based on all the attached exhibits without considering the possibly tainted buccal swab already provided. That's the argument that was made in 2018.
Then my apologies, Your Honor, that was in fact raised, but again, as the motion was not acted upon, it played no role in this court's decision.
Okay.
If there are no other questions?
Just your position on the sort of the two factors involved in the stay, the security issue, the legal issue. Is it your position that the judge could be affirmed on basically one ground completely, even if you have the best legal issue?
My understanding of the way
Not a balancing.
it's basically each factor is considered independently. There is I believe there is a tiny bit of balancing of if, say, there is a very valid appellate issue, but there is a very high risk of flight or security problems, that would suggest not releasing the defendant.
The issue's in front of the SJC. That's exactly
Correct.
the problem.
I understand that
Exactly the
Kalia
problem
is-
we struggled with in what's the name of the case?
Kalia, Your Honor, I believe.
There we go.
I understand that is on
the court's
review.
got it, so we'll find out whether there's a balancing or not.
But I also believe that this court could, because the single justice only ruled on the issue of security, this court could affirm his decision solely on that grounds and only reach the underlying appellate issue if it finds that he abused his discretion.
And we review that for abuse of discretion, correct?
Correct. And it's the single justice's abuse of discretion, just to clarify. Thank you, Your Honor.
Thank you both very much. All right. The next case on our list is John Doe, number 345593 versus the Sex Offender Registry Board, case number 2022-0802. Good morning.
Good morning, members of the panel. My name is Attorney Edward Gauthier. I'm arguing today on behalf of the plaintiff appellant John Doe. May it please the court. Mr. Doe was finally classified as a level 2 sex offender in the spring of 2019, which was 3.5 years prior to his release from the MTC and 4.5 years prior to now. We raised 3 arguments in our brief. One,
Let me ask you about the due process argument
Yes, Your Honor.
right away, because your counsel for SORP says that your client is actually eligible for a petition for reclassification right now, and your brief indicates that that would not occur until 2023.
So, Your Honor, I don't know exactly the board's position at this very moment, but when this case was briefed in 2022, our understanding of the regulation was that an individual had to be in the community offense-free for 3 years.
Ah, interesting.
And I believe the board is now, subsequent to the briefing of this, taking the position.
Well, in the briefs, they take the position, it's 3 years from the date
Release.
of the final classification. So
That
they
may-
say he's been eligible since 2022.
That may be the board's position now. However, that doesn't put my client in the position that he should be in, because if he were to petition for reclassification, first, he bears a burden of production of evidence to show that there's a change of his circumstances.
That's not going to be hard because he's reached age 60, and so he's going to be able to say that there's a difference in the regs, right?
That is true, Your Honor, but the other problem is, if he were to petition now for reclassification, he may get his hearing 4, 5, 6 months from now, during which time he remains on the internet subject to public dissemination.
So that's really,
All right, so bottom line is, let's assume it's absolutely true that as of right now, your client could petition for reclassification. That's not the relief you're seeking. You're still seeking relief that we vacate this classification based on due process grounds or other grounds.
Yes, Your Honor.
And that is your preferable course.
That is our preferable course
Just
of
wanted to be
action.
sure, okay.
Yeah, can I follow through, though? These are all the questions I had. So if we vacate, then he is removed from the internet?
Yes, Your Honor. He would go into unclassified status, so he wouldn't have a level 1, 2, or 3, and he would essentially have a new classification.
So
hearing.
when he was classified as a level 2 and it was appealed, he goes on the internet unless you get some stay of that. Is that right?
That is correct, Your Honor.
Okay.
However, he didn't go on the internet in 2019 because the SJC has ruled that individuals who are incarcerated shouldn't be on the internet because it doesn't serve a public safety purpose. So he would not have been put on the internet until he was released from
When was he
incarceration.
released?
Was that, Your Honor?
When was he released?
September of 2022, 3.5 years after the classification hearing. And he actually moved. He moved for this to be a provisional hearing because as a sex offender, he had the wherewithal to know that parole is generally not favorably given to people in his position. So he didn't get parole in 19, 20, or 21. The board should have put him in provisional position in 2019 so that each year when he came up for parole, he would have the right immediately before his release date to revisit the classification.
And what authority is there for a provisional status?
Well, what the board can do is it can give the client or the sex offender the procedural right, the procedural mechanism, so that in the event he doesn't get out, when the board predicted he might get out, that he's simply entitled to a new hearing. The provisional...
Sorry, he's entitled to?
A new classification hearing closer to the date of release. My client in 2020 and 2021 should have been afforded the right to a new classification hearing simply because he had not been released from incarceration and his hearing took place so much earlier than that time. But there was no mechanism for that. Essentially, as of 2019, when he was classified, he had no right to a new hearing, even up to 3.5 years later when he was released, because the board's position was that the 2019 decision was final and couldn't be reviewed before his release. Our position is, knowing he was going to be released in 2022, he should have been afforded the procedural right to have a hearing shortly before his release. He shouldn't have to wait, get out. And as of last...
And what case says that?
There is no case that says that, Your Honor. The SJC's decision in 7083 specifically says that a sex offender is entitled to an evaluation of his risk of reoffense and degree of danger reasonably close to when he's going to be released into the community.
I'm going to ask you to talk a little bit closer to your microphone because I got to as far as you said, reasonably, and then I lost you.
Your Honor, the 7083 specifically says that a sex offender is entitled to a classification reasonably close to his
But
date of
here
release.
his classification hearing occurred when he was eligible for parole, right?
He was not eligible for parole, Your Honor. He was eligible to be considered for parole. However,
I don't understand the difference between those two.
eligible for parole, Your Honor, simply means he's reached a point in his incarceration where the parole board can consider his request for early release.
Right, so wasn't that the reason that was given for having the hearing by the hearing examiner? She said, I'm going to have the hearing because because he's applied for parole and he could be released.
Yes, Your Honor, that was the
Why
reason.
is that an inadequate reason? What's wrong with that?
That was an adequate reason, Your Honor, for having the initial classification hearing in the spring of 2019, the possibility that he could be released. However, the fact that he was not released a year, 2, 3 years later, he should have had the procedural mechanism to have a new hearing while he was incarcerated prior to his release.
But, and that's the answer to the question Judge Vuno just asked you, which is there's no case that says that, there's no reg that says that. This is just your argument.
This is the argument based on the fact that the Supreme Judicial Court has said that sex offenders
Reasonably close to.
are entitled to have their current risk of reoffense when they're released to be what causes them to have a 3, a 2, or a 1. My client was doubly prejudiced because if he had had his hearing close in time to his release date, number one, he would have been at the MTC for 3.5 more years, presumably getting treatment. He would have been over the age of 60, which is the point at which the board's regulations give full weight to the very significant risk mitigating factor age. He only got partial weight because he's not 60. Now he's 60, he gets full weight. He also has physical conditions those could have gotten worse, and he also had more time to find a place to live.
What's reasonably close in your view? 1 year, within a year?
Within a year is typically reasonably close, unless there is going to be some sort of milestone prior to release. So if he was 59 and 10 months before the hearing, the board should probably give him full mitigating weight for age of 60, because he's not going to be 60 until he's released. But when you have a gap that's this significant, the client's position 3.5 years later, his risk of reoffense, his degree of danger to the community, could be significantly different. And in this case, given my client's advancing age, his health problems, his treatment at the MTC.
Could we talk a minute about the health problems? Because I also could not find anything significant in the record about the health problems. In fact, they were actually described as unspecified in the medical records itself. So can you point me to any place in the record that makes it a little more clear what these health problems were and how they would have affected his the idea of his risk of reoffending?
Your Honor, there is no expert testimony or expert evidence linking his medical problems to his risk of reoffense. However, he does suffer from prostate issues, issues with his bowels, issues with his heart and his stomach, and those are in the record appendix volume 2 and volume 3. I will concede, though, that there is nothing in the evidence that would tie those health issues directly to a risk of reoffense. However, 3.5 years later, because he was
You're
denied...
going to assume that maybe those issues would have been somehow exacerbated by age.
We can't establish that.
Could
but
also
we-
have been ameliorated. We don't know.
We don't know, Your Honor, because so much time lapsed between the hearing and his release. We don't know what his physical condition, his treatment programming condition. It was just... there's nothing in the law that allows somebody to be classified 3.5 years before their release. And we are now knowledgeable of the board's position that my client can have a reclassification hearing.
Excuse me, that your client what?
We are now mindful of the board's position that he can have a reclassification hearing. He doesn't have to wait offense-free 3 years in the community. Had we known that back in 2022, perhaps we would have tried to negotiate something. But I can tell the court that even if we were to negotiate a reclassification, it requires dismissing the appeal before the reclassification hearing is granted, which is a possibility he wouldn't get it. And it also doesn't take him off the internet in the interim. He stays on the internet subject to public dissemination pending the new hearing, which is...
So what do you say to Sorb's argument that even if you take factor 2 out of the mix, this is still a level 2, and it's clear? I think the language of our cases is that it wouldn't have made a difference.
Your Honor, in the case that was issued, the decision that was issued in 2022, the standard is essentially whether it's not, what if we excise factor 2? The question is, do we have to be reasonably sure that he would have been finally classified as a 2? We have to rely on the board's expertise, the board's experience as the agency in this case. It's better to just give it back to the board, in our opinion. If you excise factor 2 isn't just a normal one of the 38 factors. This is a statutory high-risk factor. The science says that an individual who is found to sexually offend is confronted and convicted, and that doesn't help them. They continue to sexually reoffend. That is the hallmark of a high-risk sex offender. So factor 2, taking it out, it's very, very important. It's the board's expertise that runs these cases, and it's our suggestion that it should be up to a hearing examiner whether removing factor 2 actually matters enough that it warrants a different level.
Okay.
Well, you know, your guy was convicted of a pretty significant sex crime at age 50, may I add, and then he's incarcerated, during which he doesn't really try to get sex offender treatment. And that's a finding of the hearing examiner. I'm paraphrasing, but it's did not make the effort that one would want to see. It's pretty significant, isn't it? That's a pretty significant finding.
Yeah, I would point out that the client in this case has a single victim. that the client offended in the 2000s, ending his sexual offending in 2009. He has nearly no other criminal record of any kind throughout his entire life. His behavior while incarcerated was he received 7 D reports over 10 years for very minor infractions. The evidence suggests that he has adapted to prison life. He is now 14 years older than when he offended for the last time. It's difficult to weigh the factors in this case, but if you take away the repetitive and compulsive, we basically have a guy who, during a period of 5 years, 15 years ago, committed some very heinous crimes, but now he's 62 years of age. He's been in the community.
He didn't take sex offender treatment, and in fact appears to still be blaming the victim, who was 5.
The victim was 5 at the beginning, Your Honor, 10 at the end.
Yeah.
There's no doubting that these cases are very hard and the facts are very difficult, but this is a significant factor, and we believe it would require a remand. In any event, we believe the strongest argument is the due process argument. And if there are no further questions from the panel, John Doe would rest on his brief.
Thank you very much.
Thank you, Your Honor.
If it pleases the court, David Chennai for the board. I argued 7083. It was an interesting case, and when I realized the SJC wasn't going in my direction, I kind of floated the idea of a provisional status, which, lo and behold, I was surprised they accepted. But the idea of it is that if someone's incarcerated, that individual, the board can do one of two things. They can wait till closer in time for their release to have the hearing, or they can have the hearing when he's incarcerated. Now, what they can do if they have the hearing when the individual is incarcerated, they have to hold it provisionally, meaning that provisionally, this is, say if they make him a 2, he's a level 2 provisionally. And
Which means
that they're just holding on to it. And then that gives the offender the
when
right.
he's released, he will go on the internet?
Well, that's the point, is that the individual has the right to ask 30 days prior to his release to reopen the evidence and put in additional evidence to show if any programs he's done or any benefits he's made while incarcerated, or what his future plans are upon release. If he doesn't ask for that hearing, the minute he's released, that classification goes into effect.
So are you describing, and I'm sorry, I should know this, but are you describing what the SJC opinion says?
Yes.
Okay, but that was not implemented here. Instead, we had a final classification hearing, even though there was a request to go down this.
Correct. Now,
That's why you concede error.
I concede error, but you know what's interesting about this case is the plaintiff had opportunities to rectify it. He filed his appeal to the Superior Court less than a month after the decision. Never went in to get a preliminary injunction against this not having the provisional status. And on top of that, when they filed their appeal in July of 2019, the attorney didn't perfect it by filing their MJP with the board until April of 2022. So the attorney for the plaintiff for 3 years sat on this and never tried to correct this situation. And the board responded to that MJP within a month, and it was in court within a month of the filing of the MJPs with the court, which is the motion for judgment on pleading. You filed the memorandum.
Could you use real words, so the what?
I'm sorry. The motion for judgment on the pleadings is after the complaint is filed. And
I get that. Okay. I just didn't know what it meant.
Yeah, and the memorandum that goes to the board, the attorney waited 3 years to file it with the board. In that interim, there was never a motion brought before any court or to the board for reconsideration of the provisional status. So there were opportunities to correct that. They just weren't taken, or at least attempts to correct it. So I concede.
And is that on them? In other words, if we were to find that actually there is a due process violation here, does it matter that there were no efforts taken by the petitioner in this case?
I think it does because, again, they had opportunities to correct this, and they weren't taken.
They
And
had
then they come
process
Yes.
available to them.
Right, and they come to this court now and say, we violated due process, and therefore this case
Let's
should
just
go
take the
back.
words due process out of it. I mean, there's error, it's conceded by you. Your opponent says, hey, if we had had a hearing in 2022 when he was being released, he would have been over the age of 60. There may have been different evidence on other subjects. That seems to me to be a reasonable argument. What do you say to that?
It's reasonable, but, I don't think it's going to change the classification because for two reasons. One is, while incarcerated, he didn't do a whole lot to better himself. But meanwhile,
We don't know that, as your opponent points out, because you had the hearing in 2019. He'd only been transferred, I think, to Bridgewater maybe 18 months before, but by 2022, he's got another 2 to 3 years.
but up until this point, no one has produced any evidence that he's done anything to support their argument that he would have had a lower classification if he was given a chance to have a second or reopen the
They
evidence.
couldn't do that in this appeal, because in this appeal, we're stuck with the record that was created in 2019, right?
Correct. But again, there was opportunities prior to this appeal for them to bring that information forward. In fact, the attorney at the Superior Court could have requested to reopen the evidence, or at least put in supplemental evidence of programs or changes that occurred. I think the reason I say I don't think the class...
Sorry, the burden would have been on Doe. The burden would have been on the petitioner.
If you're making a due process claim, you still have to show prejudice, and the burden is on them to show the prejudice.
Okay.
And they have to show why it would have been different if he had been given that chance to reopen the evidence. It's not a new hearing, it's just reopening of the evidence. What I'm saying is that the circumstances of this case are such that I don't think it would have mattered unless he completed sex offender treatment or done something dramatic, because what you have is an individual who befriends a woman and her husband, gets access to their child over a 5-year period, is incarcerated for 11 years, and now is being released into the community. I think the hearing examiner is reasonable in determining that if he meets another woman, that woman should be aware, especially if she has children, that this individual did these things. So I don't see how in 2022 or 2023 or 2021, the hearing examiner is going to be less than a 2.
Help me with the rule with respect to the availability of a reclassification. Your opponent says that until recently, the position of the board has been 3 years, not from the final classification, but from release.
It used to be 5 years from release of incarceration. The SJC said it's 3 years regardless, so we're following that rule.
It's as 3 years from when?
From the original classification.
From the final classification.
The only caveat being that the board does not give reclassifications while the individual is still incarcerated. Once they're released from incarceration, they have a right to a reclassification hearing if it's 3 years prior. That's really not an issue anymore because the board isn't doing what they used to do, which was classify as soon as they were incarcerated. They're going more towards, most of the cases now are going to closer in time to release. So I don't think that's going to be an issue in the future.
So right now, let's say that the panel decides that John Doe deserves another hearing. What is the fastest way to get to this? Is it, what I understand his attorney saying is, no, we don't want to dismiss the appeal and go for a reclassification hearing because the burden of proof is different and because we still have the problem with the dissemination on the internet. On the other hand, I'm hearing that, that might be the fastest and best route to get this looked at again. What do you say?
Well, first of all, we're doing reclassifications much more rapidly than in the past because we've actually caught up to all the reclassifications. But more importantly, the time frame would be the same because this first decision in this case was so old that they would go through the discovery process again, get updated information on this individual, allow him all the procedural steps in between. So whether he has a reclassification or a hearing, it's going to be just about the same amount of time. The only difference is if you vacate the judgment and order a new hearing, he is no longer subject to the internet because he's unclassified until we have the hearing.
And how long would it take, and I'm just asking it hypothetically, if there were a vacation, how long would it take to do a reclassification?
I would say between 3 to 6 months, depending on how much discovery is out there and availability of the...
If we vacate, is there a mechanism for the board to seek a order keeping him on the internet pending the reclassification, pending the new hearing?
I think you're talking at least 3, maybe 4, possibly as much as 5 months before you're going to get a hearing, because again...
No, I'm talking about interim relief.
Interim relief...
Any other context, you might have a, pending final conclusion, we need preliminary relief, he needs to stay on the internet. Some sort of the equivalent of a preliminary injunction. Is that a remedy that is available to the board?
I'm kind of confused by, I guess, the phrase preliminary injunction.
In other words, if hypothetically, we vacate the classification, pending the next hearing, can the board do anything to maintain the status quo, to keep Mr. Doe's information on the internet until such time as the hearing takes place?
No, because if you vacate the judgment, you vacated the board's classification.
So
And therefore, they have no power
they
whatsoever.
have no power.
Right.
Everything is in zero status. so to
Zero
speak,
status.
for the next
That's
moment.
stunning, that there's no availability for the board to take some sort of preliminary relief as you would have in any other context in our court system. Now, I know I'm asking you a question apparently you haven't thought about, but that's stunning to me. I mean, if the board says, look, you guys just vacated this, but in the meantime, before we have the time to have a full evidentiary hearing, we need this relief because there's irreparable harm, ordinarily, we would find a court to act on that.
Again, this is based on an individual being classified as, say, a level 2 and on the internet. If that is vacated, the system, the regulations, the legislation, we can't do anything unless he's been classified and held as a level 2. I mean, if you want to make that ruling, I think we'll be in the SJC about it, and I'd be more than happy to argue it.
Well, that would be a fun one to,
I guess
I'm
it's
used-
not the legislative scheme. What I'm hearing you say, it's
you think you have no power, so
We have no
can take a
power.
look.
I believe we have no power, and again, I've gone down in flames at the SJC many times, so I'd be willing to go up and do it again, so. I think I've briefed these arguments. I'd only point out in the Factor 2 issue and the specific findings, this decision preceded the rules that preceded, Justice Wilkins and then Doe 22188. It also preceded Doe 496501, which was the 3 individual
But you concede that
components.
Factor 2, so there are 2 high-risk factors, and the board concedes that one of those 2 high-risk factors should not have been considered.
Correct.
Okay, so make your best argument for
The
why it
best
is that
argument
we
is,
shouldn't
even if you
vacate.
take out Factor 2, it's still, the classification level still stands because, again, you got an individual who befriended a woman, took advantage of the situation, ingratiated him into their home, became the babysitter of this child, sexually abused the child for close to 5 years, goes to prison for 11 years. The board has an interest that when he's released in 2022 with the lack of sex offender treatment, the lack of real programming, that
We don't know if there's a lack of sex offender treatment,
well, as far as we know, based on what we have right now,
because the board didn't have the hearing closer in time to his
well,
release.
keep in mind, the burden was on the individual to request the hearing. The board doesn't automatically give the hearing, and this individual had the opportunities to go to court to get that right. He never did that. So based on that, I think getting out in 2022, I think it's incumbent that the public be aware of this individual, because if he decides to live with a woman with a prepubescent child, we may be in the same circumstance. especially considering he spent most of his years in therapy saying that it was the little girl's fault. So based on that, I just don't see him becoming a level 1 in 2022. It's just not going to happen.
Okay,
So I will rest on my brief.
all right. Thank you both. Thank you both for
Thank you.
your information regarding the process and how it works and being candidly responding to all of our questions. We appreciate it. All right. Next case. Okay. We have 2 more. So one
Want
more.
to take a short break?
What, need a short
It's up to you, Chief.
Okay. Actually, we're going to take about a 5-minute break right now, and then we'll come back and hear the last 2 cases, all right? Okay. All right, thank you very much. And if you give me one moment, I think I misplaced the number and the case number of our next case. I found it. This case is impounded, case number 2022-1052, correct?
Correct.
All right, thank you very much.
Before I begin, I noticed the clock is at 10. Are we getting 15 on the notice? Or are
You
we getting-
have 15, and the appellees have 10 minutes and 5 minutes each, right? Okay. So counselor here has 15. Thank you.
Great, thank you. And may it please the court, Attorney Robert Curtis representing the appellant father in this termination of parental rights adoption case. I'd like to I'll start from the beginning with the first issue, the jurisdictional issue. In this case, the parties had lived and were divorced in Texas. After the divorce, at some point, and it's not abundantly clear in the record, mother and her new husband and the child moved to Massachusetts.
Why isn't it clear that that was December 2nd?
Excuse me?
So why, it's not clear from the record. Why isn't it clear that it's December 2nd?
Well, because, first of all, the judge didn't so find. There was one piece of evidence that said, this was a piece of evidence dated November of 2016, that said the family intended to, or anticipated, I forget the exact wording, intended to move to Massachusetts on December 2nd.
Where was that, where was that document? Was that in the file of the Texas
It was the
court?
Texas, it was filed with the Texas court. It was a document that was filed with the Texas court.
So, why?
I
From
believe
November of 2016, hadn't the court already entered final judgment?
the court did. I believe there was an order, or it may even be statutory in Texas, that you have to inform the court. I mean, it's Massachusetts, we have the removal statute. You can't remove without, a court order. I'm not sure how it works in Texas, but I believe that was the point of why something was filed in Texas. This exhibit was all admitted as a, most of the Texas file, I believe, was all in one exhibit. That same exhibit also contained documents.
The file from the Texas divorce was admitted into evidence in the adoption proceeding?
Yes. I mean, I can't say for sure if it was every paper from the Texas file, but all the relevant ones, or the ones that should have been relevant to this case, were filed, I believe, as a single exhibit. That same exhibit, so it had the November 2016 document that said we intend to move on December 2nd, but the same exhibit also had a September document that said we intend to move to Massachusetts.
So they changed their mind and they had a better date. 2 months later, they knew exactly what date they were going to move. It was December 2nd.
Or a week after that, the plans changed again. We don't know that. All we have is this
No one raised the issue.
You don't need to for jurisdiction.
So, counsel, I understand your position, but it seems to me that that's a fairly facile view of what a court has to do under these circumstances. Are you saying, under our state law, that they were obligated to put in the evidence that the child had been there for 6 months beyond what was already? So what case are you relying on that says that?
A case that says that specifically, there probably isn't a case. But there are plenty of cases that say jurisdictional statutes are strictly construed. The one I wrote down was, and I didn't write down.
Okay, I accept everything. I mean, the only evidence we have, as Judge Singh has already pointed out, indicates that the child had been there for 6 months, that the child had arrived in Massachusetts on December 2nd, and that they didn't commence proceedings until June 2nd of 2017.
Right, but yeah.
So why is it, I'm struggling, I've gone back and thought about this a little bit and tried to take a look. I'm struggling, what you're arguing is, as a matter of fact, jurisdiction was not established. And my question is, what was the obligation that you say they had, beyond what they've already done, based on the law that you need to cite to us?
The obligation is the statute that says home state jurisdiction requires at least 6 months worth of residence. So that's the starting point. We know that it has to be at least 6 months. So now we look at the record. And the record, the judge did not make a finding other than just the very vague December 2016. And there was some evidence the December 2nd document, but within that very same exhibit, there was contradictory evidence that used a different date. And in any case, that exhibit was created before December 2nd, so we don't know what happened since then.
But doesn't the petition itself allege, we've been here, the child has been here 6 months?
Not really.
Does the petition specifically allege that? I'd have to look back at the petition. But even then, it's an allegation. It needs to be found, I think. I mean,
No, that would not be true, but unfortunately, I looked at the petition, and I don't think it says that.
yeah, I didn't think so either, which is why I wasn't prepared with an answer to that
That would
question.
not be true. If there were an allegation in the complaint that's not contravened, that would be sufficient. But, you know, it's a very odd construct that you're imposing on us, because although it's true that subject matter jurisdiction can be raised at any time, there is nothing in the record that indicates that there is not subject matter jurisdiction.
But I don't think subject matter jurisdiction is established by a lack of contrary evidence. It needs to be affirmatively established. I mean, that's the statute. You know, so I don't have a case that I can point to today. There may be one. I don't have that. But the statute says that. Home state jurisdiction, and it's plain, unequivocal, unambiguous language, at least 6 months.
Counsel, is the issue that the judge didn't make an explicit finding, or is it the issue that you cannot make the finding based on the evidence in the record?
Well, it's both. I mean, had the judge made the finding, I don't think we'd be pressing this issue, because then you'd have a fact finding by a fact finder saying that the jurisdictional facts are established on the record. But because the judge didn't make it, there's nothing else in the, I mean, for you to look at the record and rely on that one document, December 2nd, you're making a fact finding at that point.
No.
Based on that, well, you are, because
No, we're reviewing the record for sufficiency as to the issue of whether jurisdiction was established. Which is our job.
right, but you're you're deciding to believe that evidence that says we intend to move here by December 2nd was actually what occurred. That's a finding. So you do have to make a finding there. There's evidence. I don't
You're
deny
not gonna
that there's some
convince me of
evidence in
that,
the record,
counsel.
but it's disputed.
All right.
It's not conclusive, you know, and so I think you have to look at that, and I think, you know, how do I put this? What I think the problem here is, if you're going to decide that this record shows enough to rule that there was jurisdiction, but you do that in an unpublished decision that's never going to have any effect in any other case, that's not really the way this should roll. I mean, jurisdiction's an important enough issue that it can be raised here for the first time, which is what I'm doing.
Very unusual jurisdictional provision, right? It's jurisdiction over the res. It's not what this court had jurisdiction to decide adoption issues, and it had personal jurisdiction over the parties, and the father was properly notified. What you're talking about is a peculiar statute that talks about jurisdiction over the res, over the child. I understand your point. There are a lot of other issues here. Maybe we should move on and talk about those.
And in fact, I mean, the reason this issue was important, and I'm transitioning to the next issue, is Texas already exercised jurisdiction over this child and in the custody of this child. And Texas had already said the evidence does not warrant terminating father's parental rights. So, you know, the first issue is maybe Texas should have heard this second petition as well, but B, the judge here didn't even acknowledge that particular holding. There's one...
Oh, can I ask you, I'm sorry.
That's time-specific, right? That's not a determination that can't be, even if I, you know, agree with your characterization of how this had gone, that's not a determination that can never be revisited.
No, correct. To some degree, it can be revisited, but the Texas decision has to be the starting point. You don't just wipe that
Okay,
away.
so two things. I looked at the record, and I don't see any basis for the Texas decision. I simply see a sentence that says, I decline to terminate parental rights, right?
Right.
So nothing was put in the record as to the judge's reasoning by you, right? This is your burden or the father's counsel's burden to show, hey, based on the proceedings that took place in Texas, you should be precluded as to this issue.
Well, and Father did argue that the Texas decision, I mean, you're correct.
No, but I'm talking about the facts, all right? The burden is on the father who's asserting a defense of preclusion, right? So what do we have in the record that tells us what was litigated as to the issue of termination of parental rights in Texas?
Right, so the information you're looking at in that question is not in the record. But I don't know.
Whoa, seriously? So it wasn't even presented to the trial court? So there's a motion to dismiss. What was presented with the motion to dismiss?
The judgment is in the record. And the judgment including the provision that there's not.
But you have to show that it was fully and fairly litigated in Texas before you could have a chance of winning that argument. What was shown to the judge in Massachusetts about whether it was fully and fairly litigated in Texas? Nothing?
I want to answer your question, but I want to take a step back because I don't know that the question is really the direction that I'm arguing here. We're not trying to say the judge was precluded from considering any of these facts. I mean, I know as a matter of law, in custody cases, especially cases involving domestic violence, you know, the court can look back at facts that occurred prior to a prior judgment. But what the law says is that that's the starting point. I'm sorry, I'm going to have to shuffle some papers so I can get the citation, because there was one case that unfortunately I didn't spot in time to put in my brief, even though it's an older case. But custody of a minor, number 2, the proper focus of an inquiry in a case such as this is on those facts that have undergone some metamorphosis since the prior order or are newly developed, in consequence alter the relationship between.
Let me stop you because maybe I misunderstood your argument. Your argument is not that the Texas judgment was preclusive as to the issue of, in this case, preclusive as to the issue of termination of parental rights.
Not entirely preclusive, because I mean, I think there's enough authority out, but it needs to be considered, though.
What was the error if it's not entirely preclusive?
It's a starting point. So the judge had to acknowledge.
How does the judge know where to start when he doesn't know what the findings were or what was litigated in Texas? Because it wasn't provided to him.
The judge starts from.
Was it a her? I think it might have been a her.
Her. The judge starts from the point that and forgive me on the date, I think it was early 2016, maybe 2015, the divorce judge in Texas said, as of this point in time, there is not enough to warrant terminating father's parental rights. So from that point forward, the Massachusetts judge.
So I disagree. I think I understand this argument. You're saying that there had to be changed circumstances from whatever was provided to the court in Texas.
Changes in circumstances
But we don't
since
know
that date.
what the baseline is. No one apparently, that's why I'm asking the question, no one presented the record to the court that explained what was litigated in Texas, and we don't have any findings from the judge in Texas.
Well, and so, and perhaps you'll allow me to do this as a letter, because I don't specifically remember those things, but like I said, the entire, or a huge part of the Texas file is there. So that information may well be in the record. I don't have that at my fingertips today. I'm not sure. When you say that it's not there, I was, assuming that you had looked and it wasn't there.
Oh, no, I apologize.
Okay.
It's not in the briefs.
Right.
Okay? And which is what I looked at first.
Right.
And there's no reference in the briefs to how this issue was litigated. So, it's a very interesting question at an intellectual level. To what extent is what happened in Texas preclusive in Massachusetts when the two are relatively close in time? The first question I would ask is, what happened in Texas? There's no reference to it really in any depth in the briefs.
Right.
I looked at the judge's findings. He doesn't make any. So I'm struggling with how because on this one I'm sure you have the burden, how you have proved that case.
Okay. If with the permission of the court, I could submit a letter with a citation if those materials are in the record, 16L or whatever the new rule is.
Well, we won't give you permission to do that now. If you file a letter, we'll determine whether or not
okay.
it's appropriate under the rule. I can't.
Sure. Sure, but so I will do that, and then you can make your ruling.
Well, you'll do whatever you want to do afterwards, and then we'll determine whether or not it's appropriate. But isn't it also significant that the only line about this is simply a declination, that the judge in Texas simply says, I decline at this point in time to terminate the father's parental rights?
Unfortunately, I couldn't hear the first part of your question.
I mean, isn't it also significant that all that was said about this by the judge in Texas is that there's a declination to address this issue? There's no comment that says, I find there's not sufficient evidence, or I find there is sufficient evidence, just, I decline at this time to address this issue.
But isn't that a finding by the judge that there wasn't adequate evidence?
I don't know.
I mean,
I think that's open for interpretation, potentially.
I think, well, that may be, but again.
I see your point of view on it, but.
Right, okay. I'm out of time, but I only gotten to.
No,
so I don't know if you're.
Time, and we have no further questions. So
Okay,
thank you very
great,
much.
thank you.
Members of the panel, may it please the court, my name is Lisa Marino and I represent the appellees. Before I turn to my argument, I just want to raise the point that I had filed a motion to strike the appellant's reply brief because it was filed a month after the last deadline, and it was filed without seeking permission to file it late first. So I just want to address that. I'm sure that the court will take that into account.
And I want to remind you, I believe that all the names in this case are impounded, not just the names of, not just the name of the child, so we won't refer to any names from here on.
My apologies, Your Honor. We're asking this court to affirm the termination of the parental rights of the father and to uphold the adoption of the child by the stepfather and the mother at this time. The facts below of the unfitness of the father were overwhelming and incredibly compelling. The court found under 4 separate grounds under Chapter 210, Section 3, that he was unfit when only one ground is necessary.
Okay, so I understand the argument there. Overwhelming and incredibly compelling. I'm going to give you a hypothetical at 5,000 feet, and then you need to deal with it. Your client litigates in Texas the unfitness of the father in 2015 and loses. There's a finding of the judge the father is not unfit. Less than a year later, your client goes to Massachusetts and argues that the father is unfit. The defense is, hey, I just litigated that in Texas, and I won. Now, help me out of that issue.
So, Your Honor, that's a multifaceted issue, and I'm happy to speak to that. First off, children's needs are ever-changing, and anything can be modified.
This is about termination of parental rights, which is a fundamental right of the father. So the children's needs can't be the only issue. In fact, they can't be the supervening issue with respect to termination of parental rights, can they? I don't think you're going to be able to cite me a case that says that.
Understood, Your Honor.
Fitness, custody, different issues, okay?
Yes.
But this is termination of parental rights.
And the termination of the parental rights, what I would suggest to this court is that there were many factors that came in between the time that the divorce trial in Texas ended, which was, I believe, in 2015, and when they came here and originally moved here in 2016 and then began the action in 2017.
And so what are those?
So first off, my clients became married. There was the involvement of a whole nother party that was involved here, and that goes, as I can see Your Honor thinking about it, that goes more towards the adoption. However, I do want to point out that there were many more facts that were developed.
I suppose that could also be the following. The court in Texas was not told that the mother had remarried and had someone who was interested in adopting the child.
She hadn't remarried at that time.
Right, so the Texas court did not know that fact.
That's right. That's right.
Could not have known that fact.
Could not have known that fact, and that fact may not have existed because their relationship was still relatively new at that time, and to adopt a child is a very large undertaking. I also want to point out that there was significant testimony and development around the other pieces around the father here. The father was in jail. He was, not only did he commit these heinous acts against the mother, but while he was in jail, we learned that he had access to daily counseling, and he also had regular access to services, but he didn't use any of those. He went and took those classes only to reduce time on his sentence. He didn't accept responsibility of his actions. He continued, after the denial of his appeal, he continued to try and petition for a new trial. He refused to accept responsibility, which is one of the issues that is new and different from when they were in Texas. And so I also just want to point out, and this is not in the brief, but I do handle adoption work regularly, and I know that the courts of Massachusetts are very disinclined to terminate parental rights when there's not another parent to step in and assume the responsibilities. So even though he may have been unfit at that time, the declination may have been solely for that reason.
Is it correct that there was no reasoning from the Texas court at all on this issue?
That is correct, Your Honor. What's in the evidence?
Any reasoning from the Massachusetts judge when the motion to dismiss was denied?
The motion to dismiss focused primarily on res judicata, Your Honor, which I would argue is not really relevant in child-related welfare issues.
Res judicata doesn't apply in child-related issues, and it applies in everything else?
Well, Your Honor, a child's needs change, and because of that,
Changed circumstances is a standard reason for res judicata not to apply. The notion that the entire area of law should be thrown out is anathema to me. I understand that it's been suggested. It's just really hard to believe.
I understand, but I think that in most cases where res judicata is raised, there's a final judgment. And with children, with the exception of adoption, there is rarely an termination of parental rights.
You're right. Here there was a final judgment. There was a final judgment in Texas.
I'm sorry, Your Honor, I didn't hear you.
It was a final judgment. The Texas judgment is final and unappealed.
Well, there was an order. I would argue that it wasn't a judgment of termination. I would say that in the Texas order, it says that the order denies the termination of parental rights. It doesn't call it a judgment, to be honest with you, Your Honor, and you can see that from the exhibit, which should be part of the record, because the divorce judgment from Texas is in there.
You're saying that the divorce judgment in, I think it was March 1st, 2016, was unappealable?
The judgment of divorce, I mean, I think the judgment of divorce is final. I don't know what the Texas law is around appealing a judgment of divorce, but I would say this was subsidiary. And I do, want to point out that they did address other sort of custody matters and things like that, which are ever-changing and ever-evolving with the child. I'm happy to answer any other questions, but I can also speak to other issues if the court is concerned or has questions.
Would you like to address the adverse inference argument?
Yes, Your Honor. I mean, I think that the adverse inference issue is a non-starter. I think that it was conceded by father's trial counsel, who was, very able and competent. It was raised both in a motion before the trial, well before the trial date. It was raised before the trial began on the day of trial, and then it was argued again in the midst of trial. We talked about and discussed the adoption of Cecily at that time, which specifically states, it's this court, that it allowed adverse inferences where the mother was facing criminal charges and did not testify in a petition to dispense with the right to consent to adoption, which is essentially the same as a termination of parental rights. And so father conceded on that, and even more so, in that case, the mother had been facing them. It can be argued that in this case, the father wasn't facing any criminal charges. He'd already faced them, been convicted of them, and the appeal was denied. So he didn't really have any risk. And so I would suggest that it's just simply not an issue. But if the court is inclined to find that adverse inferences are an issue, there was exactly one finding of fact that referenced it out of 170. There were 18 separate exhibits, 5 witnesses, 5 days of trial, including an expert witness that testified to all of this. The adverse inference, if any was found, was icing on the cake. There was such overwhelming and significant evidence as to the father's unfitness that an adverse inference was not necessary, and so it could be disposed of without finding that there was any error here at all.
What do you say about the jurisdictional question?
Your Honor, I think...
Do you have an affirmative obligation to plead or to prove jurisdiction over the child?
Your Honor, I would suggest, as the court had raised, that it would be the father's burden to suggest that that was an issue. They did bring a motion to dismiss under the grounds of res judicata. That would have been the time to raise a jurisdictional issue. They didn't raise a jurisdictional issue because it didn't exist. And I want to point out that at the information saying that the mother and the child were going to be moving to Massachusetts was filed 9 days before they moved. There's other evidence that says they were stated. It was required by the court. Why would she file something that was incorrect at that point? I also want to point out that Umina versus Malbika states that the trial court is not required to make explicit written findings regarding jurisdiction where there's no suggestion that another state was seeking to claim jurisdiction.
What are you quoting from?
Umina versus Malbika, it was a removal case from 1989 from this court some time ago.
Is it in your brief?
Yes, it is, Your Honor, but I'm happy to provide you with additional information.
That says the court's not required to make explicit findings where it's not raised. Okay, thank you.
And I also just want to mention that aside from the home state jurisdiction, there's also default jurisdiction. There was no other state besides Massachusetts that could claim jurisdiction. The issue that father raises around Texas's jurisdiction, stating that father was there or he was at least a domiciliary, doesn't hold any water. The Texas court had specifically adopted the UCC JEA, which said that the issue to be considered is where they presently resided. Nobody presently resided in Texas. Thank you, Your Honors. I would ask that you affirm this decision.
Thank you very much.
Good afternoon, Your Honors. Daniel Katz for the child. With me is Attorney Mike Rich, who was the trial attorney. I would like to quote several cases that talk about the importance of child welfare in this area of the law. In adoption of Carla, this court said that in any proceeding involving the custody of a child, concerns of res judicata must inevitably give way to an overriding concern for the welfare of the child. In 1932, the Supreme Judicial Court in Richards v. Forrest, at my brief at page 32, said, "It has been said that the first and paramount duty of courts is to consult the welfare of the child. To that governing principle,
Do you have a case that says the welfare of the child supervenes the termination of the parent's fundamental right?
It is the paramount concern when deciding whether to terminate parental rights.
There's a case that says that the welfare of the child is the paramount concern in terminating parental rights.
There's a case that says in the overriding, in cases involving the custody of children.
Custody is different. We're talking about a fundamental right. We have oodles and oodles of cases that talk about what it takes to terminate a parent's rights, and the welfare of the child can't supervene that body of case law.
But the welfare of the child must always be connected, right? This court and the Supreme Judicial Court always talk about when there has to be a link to harm. Pardon?
It's a relevant consideration.
I would argue, Your Honor, that when the harm of the child is at issue, that is what the focus has always been.
Well, look, I don't want to fence. I have difficulty with the way some of these arguments are framed, because they're framed in terms of the child's interest in having a stepfather, and that therefore that is a reason to terminate the father's fundamental right. And well, no, there are definitely arguments to that effect. For example, the argument about his ability to inherit from the stepfather.
The evidence that I put in my section of the brief concerning the fitness of the father has to do with the domestic violence.
I'm with you on that.
And in addition to that, the shaking of the child and the indifference towards the child. Okay?
Totally get it.
Harm to the child. Now, in terms of the court in Texas, right, we only have that one line, I decline to. So we don't have, as Your Honor pointed out, we don't have the reasoning. We don't have the factors. So given that, along with the principle that the welfare of the child is of paramount concern, I mean, let's look at whenever the court, United States Supreme Court, Supreme Judicial Court, talks about the fundamental rights of the parents, it's never in a vacuum on its own. It's always limited by what the state can do in terms of protecting anything that has been harmful to a child if there is clear and convincing evidence that shows a link from whatever the condition is. And here, the evidence is indeed overwhelming. And I suppose it might be different, well, it would be strange actually if the Texas court took evidence or laid out findings about domestic violence and the indifference towards and shaking the baby and then declined to do so.
Did you take a look at the record in the Texas court? Is there, if and when we take a look, well, we will, when we take a look at the Texas record, are we going to see a thoroughly litigated case of unfitness of the father?
I don't know the entire record. What I glean from the decision is because of that one line, I would argue no. And so the Massachusetts court, given the principle, which I'm trying to implore your judge, the paramount importance of the welfare of the child.
I don't know that we're in a different place. I heard the argument differently because of where it started. So I don't think we're in a different place. Don't worry about it.
But, you know, there was no listing in findings. Right here, we have findings of fact and then conclusions of law, and then oftentimes in the form of the decision, you see in bold-faced type a judge referencing to the specific findings, the domestic violence, the shaking of the baby, right, the indifference to taking care of the child, which we all know, of course, is also one of a factor that can be used.
One other question.
Go ahead.
In the Texas judge's order, he specifically says something like, the father will have none of the rights of a parent under Texas Code X, Y, and Z. What are those rights that he's not getting?
Your Honor, I wish I could tell you that I'm an expert in Texas law, and I am not. But I do not understand, and thank you for bringing that up, why the judge made those statements, made those written statements, and then, you know, judgment for mother in that area, and then just said, I decline to terminate. I am truly...
Would the father still have to pay child support if his parental rights were terminated?
I mean, no, he's terminated, so... Okay. Oh, are there any other...
Your time is up.
Oh, sorry.
I don't see any other questions, any remaining questions, so thank you very much.
Thank
Thank you
you.
all very much for your argument. We'll take the case under advisement. Okay. Our last case on the list for today is case number 2021-1019, JK versus EK. And this case is also partially impounded. Good afternoon.
Good afternoon, Your Honors, and may it please the Court. Kevin Powers for Attorney Celeste J. Tamori, Special Personal Representative of the estate, who is with me here today. Your Honors, 3 clear errors and 1 important distinction warrant reversal. First, there were at least 8 instances within the judgment nisi, the rationale, and the partial Rule 59 judgment of clear, unambiguous, mandatory language that the wife will no longer receive the stream of income and that the husband shall retain as his individual property and shall receive this stock. And we list those at the table at a
And again,
brief.
that was in the rationale, not, correct?
Across the 3 documents, Your Honor, in the judgment itself, at page 18 in the appendix, the divorce judge stated it is further ordered that the economic rights and responsibilities are disposed as follows. She then stated at pages 20 to 21 in the appendix, the husband shall retain as his individual property the following assets, and then listed as asset number 5.
Right, I follow you. Okay, that's part of the rationale. I follow you. Go.
Oh, I'm sorry, Your Honor, that was in the judgment nisi, not the rationale.
All right.
The rationale then did expand upon that, as did the stipulation in the partial Rule 59 judgment.
Let's assume, for purposes of hypothetical, that at least this judge agrees that the order writ large was clear, so there was a clear order. Was there clear disobedience? She provided the certificates to the attorney, which is what she was ordered to do. So what more did she need to do?
Your Honor, she needed to act as she was with regard to the to the agreement and to these orders as a fiduciary, and to actually perform and actually effectuate what was ordered and what was articulated.
Again, what was she supposed to do precisely?
She was supposed to convey the
Write a
shares.
check once that dividend came into her account? Write a check out of the account?
Your Honor, she was to ensure that the income would no longer be included in her income stream, and she was to convey the stock.
She had no way to stop the checks from coming to her once the stock certificate had been provided as she was ordered to do, right? Then it's in the hands of the husband, who, as I understand it from the record, now you correct me if I'm wrong, could have handed the stock certificates to his financial advisor, who then could have, the words used is instantaneously, but fairly simply have done something that would have caused the dividends to start coming to his account.
Your Honor,
Am I wrong about that?
Respectfully, Your Honor, the shares were in the sole Social Security number of the wife, not of the husband. They were listed as in both of their names in terms of the mailing address, but they were strictly and solely in her Social Security number.
Is the answer to Justice Engler's question that this financial accountant could not have done anything? Is that the answer? Is that what your answer is?
Not without the wife completing the transfer form, Your Honor.
Was she ever given the transfer form?
Did anyone ever write her a letter? Is there anything in the record that says, hey, I can't get this done because I need the transfer form. I need you to sign something more.
Your Honor, husband passed away on August 2nd, 2021. Within about 2 months.
So that's not an answer to my question.
Beg your pardon?
And I don't think it's an unreasonable question in light of the record. My question is, when she provided the stock certificates, did anyone say to her, we need you to do X in order to complete this transfer? Is there anything in the record that will tell us that that happened?
At that moment,
Well, it's not a moment because it's from 2017 to 2021. You just started telling me about what happened in 2021, and as I understand it, she provided that was it maybe even earlier than 2017? It was 2009, right?
I believe 2008, the wife testified that she handed the physical
The next
certificates.
13 years, did anyone say, hey, we need your help to get this transferred?
I don't believe that there is, beg your pardon, for the next 9 years to 2017. From 2017, then people very much did begin to impress upon her.
So for the, thank you. So from 2008, she hands the certificates as ordered to the husband's lawyer. The evidence in the record that we have, which I understand you to be disputing, but honestly, there are no findings on it. But the evidence in the record that we have is that if that money, I'm sorry, if those certificates had been given to the financial advisor, he could have effected a transfer by which the dividends were then going to come to the husband. You say, no, they couldn't do that because it was in her Social Security number. Not in the record that I understood, anyway. But still, did anyone ask her for those next 9 years? Hey, we need your help.
I would have to check the record, but I don't believe that there are findings that anybody did ask her for those next 9 years. However, Your Honor.
How is there clear disobedience here, which is under Smith against Smith is required? They're separate questions, right?
Because, Your Honor, the relevant question in this civil contempt, as Chief Justice Turow emphasized and focused upon, is objective compliance and not subjective intent. That wife, under some constellation of circumstances, might have been assisted under some hypothetical scenario, that someone might have said to her, here's a form, sign here. By the way, you need to order the following form. And someone might have assisted her at some point in the process, certainly. But that isn't the standard. The standard is, was she capable of doing it? Did she do it, or did she fail to do it? And she didn't do it. Indeed, in 2017, 2 months after husband passed away.
What is it that she didn't do? We're back to Judge Vuno's question. Was she supposed to not collect the money that was being sent into her account?
Your Honor, she was to obtain the transfer form from ComputerShare, which was the company through which they had bought and traded these shares, and complete that form and submit it. Indeed, it's the form that appears for the Kmore shares on pages 180 to 182 of the record appendix. A very short, very simple form, and wife, 61 days after husband passed away, she got that form, she completed it, and 4 days later, as indicated on pages 183 to 185 of the record appendix, she received confirmation of that transfer having been effected. In other words, when she wanted to, when it was in her benefit to transfer those shares, in that instance, into her
13
soul.
years later, there's nothing in the record indicates she knew that she could do that in 2008, is there? Or any time up to 2017?
There was nothing that prevented her from finding out, from asking, from calling up ComputerShare and saying.
But the evidence that she did ask certain people of authority, and they did not tell her to do that. And the judge found that explicitly, that she was not told to do that. To the contrary, the judge found that she did ask the Mr. Powers, I believe the name was, the master that had been assigned, and other people, even family members, and was told, don't do anything.
And, Your Honor, acting on the advice, be it of counsel, of other professionals, is again legally irrelevant to the question of civil contempt.
Wouldn't it have been irrelevant if one of them had said, get the transfer form? If someone had said, if there was evidence that someone said, get the transfer form, I think your argument would be different, right?
Well, that would provide
So
additional.
it cuts both ways.
Beg your pardon, Your Honor?
Cuts both ways.
Perhaps, but Your Honor, she was perfectly capable of calling up ComputerShare and saying, I've been ordered to transfer these shares. What do I need to do? And a representative of ComputerShare could have said, oh, very simple 2 to 3 page form. We'll fax it or email it to you. Fill it out, fax it or email it back. It'll be over and done within probably 48 to 72 hours.
Except she says that it would have cost her $6,000 because she didn't have the certificates anymore, and she would have had to get those certificates reissued to her name.
And Your Honor, if that created, for clarity, we do not concede that that creates any ambiguity in wife's obligation. However, if that did create any ambiguity in wife's obligation, her method of recourse, as set out by the SJC in Judge Rottenberg's Center, was to seek clarification from the one authority who could actually give her a binding answer with real certainty, the judge. She could have gone back into court, as she did numerous times in the course of litigating the various contempts against husband, and requested clarification, moved for clarification, sought clarification, and gotten definite clarification as to, okay, here's the status of what I've done. I turned over physical paper
She might have if
certificates.
anybody asked her, if anyone had brought a contempt against her during that period of time, but that didn't happen. On the other hand, what happened is that husband was not fulfilling his obligations.
Your Honor, if I understand Your Honor to be asking about.
In other words, you said she could have, all these times she went to court, she could have asked for clarification. At no point in all those times she went to court did anybody bring it to her attention or say that you should be held in contempt for not having done this. That never happened.
Not in those contempt proceedings, Your Honor.
It just seems, a strange position to me that when someone actually does exactly what they're asked to do at the time, that your position is, well, they actually had to do more. And that's what we're concerned about. And of course, here the judge said, well, no, she didn't have to do more because there was no actual unequivocal order for her to do more. Right? So you're saying that finding is what, clearly erroneous or an abuse of discretion?
Clearly erroneous, Your Honor, because the contempt judge imported an incorrect legal standard, a standard of intent, bad faith, or willfulness, all of which are entirely irrelevant. The standard is objective performance and not subjective intent. But
can I ask? Can I just shift for a moment? What is in the record about the dividends that were actually received by the wife? I saw a listing somewhere that goes back to 2008, indicates about $35,000 worth of dividends or something to that effect. Is that in the record?
Yes, Your Honor. I believe the amount of dividends that we tabulated from the tax returns in the record are just either side of, I think, just over $38,000, and that appears in. If Your Honor will forgive me just a moment, that appears in
that's
footnote.
consistent with what I saw. So that's in the record. So what do you say to the judges? So in Smith against Smith, we said not enough for contempt, but the question of whether the husband still owes the alimony is still open. That's a separate question. So what do you say to the judges? I have difficulty figuring out what the judge is getting at here. Notwithstanding the finding of no guilt, this court reviewed whether monies should be ordered paid from defendant to plaintiff, the estate, for the time period after the death of the husband. What do you make of that part of the court's opinion?
Clear error, Your Honor.
What should the court have done?
Your Honor, that clear error results from the fact that the court had before it an exhibit of wife's 2017 tax return. That 2017 tax return covered not only the quarterly dividends prior to husband's death on August 2nd, 2017, but also dividends after, quarterly dividends after husband's death on August 2nd, 2017. And therefore, the judge beg your pardon, the contempt judge was simply incorrect as to the state of the record, as to the state of the evidence.
On after his death, but why is he even asking the question after his death? Why isn't the question, how much did she receive that she wasn't supposed to receive? It's a bit of a softball, but did you folks ask for that? Did you ask for all the money that she had received in dividends?
I believe so, Your Honor.
Where will I find that?
I would have to check the record, and I'm glad to send the court a 16L letter if that be appropriate.
It's in the record, we'll find it. So.
Thank you.
Thank you, Your Honor. And if there are no further questions, and on the basis of those arguments and the arguments in the briefs, we respectfully request that this court reverse, direct the probate and family court to enter a ruling of contempt and award fees and costs under Chapter 215, Section 34A, Sub A, Paragraph 4. Thank you, Your Honors.
Thank you.
May it please the court, Margaret Carleen on behalf of EK, who I'll refer to as wife in this matter just for ease of reference.
Sure.
In this case, the court did not abuse her discretion in finding wife not guilty of contempt. As an initial matter, just to clarify, the plain language of the original order, the divorce judgment, simply said that the husband shall retain as his property, and then there was a list of assets, and included in that list were the 3,000 and change shares of DuPont's stock. That judgment was later clarified, of course, by the stipulation between the parties where the wife agreed to present husband's counsel, deliver to husband's counsel at an appointed day and time with the physical certificates. The judge, of course, expressly credited the wife's testimony on that. There was no other evidence other than the wife had written to the special master. There was a letter that was admitted. The wife had written to the special master, which essentially corroborates that, because she says in the letter, husband's counsel has everything needed. Please effectuate these transfers. This has gone on too long. I think the court highlights an important issue as far as asking what is it that appellant contends needed to be done under this order. Of course, one of the essential elements in showing a contempt is that there is a clear and unequivocal order in the first place. Here there wasn't. On page 28 of appellant's brief, the appellant indicates that the obligation would be an obligation to deliver the DuPont shares and the dividend stream.
What are we to do with the rationale?
Well, the appellant argues that the rationale should be considered as part of the court order. That, to me,
I think it says, I don't think that's what they argue. I think they argue it should be considered in conjunction with the court order.
As if it's a court
And
order.
the rationale says the husband shall receive this stock in the division of assets in order to equalize the parties' assets, so this income shall no longer be included in the wife's income stream.
Well, to that we would respond that first, there's no specific directives to the wife. Also, this was supporting language, explanatory language, in a context of calculating the amount of alimony.
Are you saying that we can't consider what the judge said in terms of determining whether it's a clear order?
I think that in considering the black letter law, it's whether was there a violation of an order. So if the court wishes to consider the rationale as part of the order, then certainly that would be part of the order, but we would submit that it's simply explanatory, and it puts an onus on a party to have to comb through a lengthy rationale and try to determine what their obligations are, when the idea is to make sure that parties have sufficient notice of what it is they could be accused of violating.
Yeah, I have difficulty with this. I have to say I have difficulty because that language, so this income, was omitted when there were descriptions both, I think, by the judge and in the parties in your brief. I mean, that, I don't think it could be clearer that the judge is saying in the rationale, stock's going to the husband, this income is not going to the wife. The wife then receives the income for 9 years.
But given that Of course, shares in a dividend stream is not a physical asset. It can't be, it's an ownership interest. It can't be put in a box and delivered to someone in the same way the physical certificates can. That in itself highlights an ambiguity. It's very difficult for someone to understand what is required of them. Unlike the stipulation where there was a specific day and time for compliance, it was spelled out exactly who to deliver those to.
And how much do you think, if I may interrupt, do you think that that stipulation, that part of the amended judgment, so to speak, right? To the extent it clarified exactly what the wife was supposed to do, pick up the certificates and deliver them, and didn't say anything else, does that sort of supersede what was potentially inferable from the rationale?
I think it did because in her mind, which is relevant, she understood that she had complied with all of her obligations by delivering the physical certificate. And the evidence is replete with evidence that which the court credited. She had asked 3 different attorneys, including husband's own counsel, the special master in the case, and her son, who's also an attorney, asking for advice as to what to do. All 3 of them told her, just hold on to the dividends and wait for husband to transfer them, which of course he never did, despite the urging of the financial advisor.
What's your, actually, if I ask for your understanding, it would be a question that I really would care about the answer to, but I think it's unfair. So let me ask the question instead. What's in the record as to what can happen once the certificates are in the possession of the husband as to him affecting a transfer of the asset?
So the financial advisor testified, and most of the financial advisor's testimony was expressly credited. The advisor indicated that he had, I believe there is a finding that he met with the husband about 24 times, and that he had urged the husband and brought the issue up because he had created a brokerage account and wanted the stock to go into the brokerage account, and he had asked the husband about it. The husband essentially dismissed the advisor and said, "We'll see," so he was well aware. The advisor testified that had the husband simply given the word, the advisor could have instantaneously transferred with or without the certificates. Presumably, the husband would also have to pay that $6,000 upward fee, but that could have been done.
No, he doesn't have to pay the fee. He has the certificate. It's the reissuance of the certificate that causes the fee.
That's exactly right, Your Honor. So we don't know what happened with these certificates. All we know is that wife delivered them to husband's counsel. From there, whether husband's counsel had them and they just didn't want to transfer or they lost them, we don't know. But either way, the transfer could have been done by the financial advisor.
Well,
That's the only evidence we have in any event. Is that fair to say? Just to follow up. Okay.
You're correct, Your Honor.
is the word instantaneously, which was not a finding of the judge, but simply the testimony of your client, of the financial advisor who was otherwise credited.
Yes, most of the testimony of the advisor was expressly credited, yes, not that particular.
Doesn't the wife owe the money? Let's assume for now, as a hypothetical, that we were to conclude there was no contempt, either because it wasn't clear order or because there was no clear disobedience. Doesn't she still owe the money?
In other circumstances, perhaps the estate would have a claim. But here, and the Wooters case does tell us that all of the circumstances should be considered. It doesn't seem like an appropriate or just result to find that the wife owes the money. The husband had been very difficult throughout the divorce litigation. There were at least, I believe, 14 contempt actions against the husband for failing to make transfers.
So this would be the defense you would raise if the case went back on remand?
So is Your Honor assuming that there was a clear order and there was clear disobedience of that order?
No, I'm assuming that there's no contempt, but there's a request. I'm assuming, you know, this is Smith against Smith, right? Where we said there wasn't contempt. It wasn't sufficient that there was any proof of, there wasn't sufficient proof of clear disobedience. We're going to, however, and we affirmed the judge on that. However, there's still a question as to whether the alimony is owed.
So the contempt question is a very different question than, so suppose that the personal representative had proceeded to file a complaint in equity. What's before this court may be very different. But what was before the court was a question of, was the...
You don't think that the request, the contempt filing subsumes a request for the money? The judge addressed it in the last lines of his order.
Well, I think that the contempt issue was the issue before the court. I also think that the court correctly and was within her discretion to consider the other factors that were before her and that she made specific findings on, the husband's behavior during the divorce proceedings, the fact that husband never raised these claims despite having ample opportunity to do that, the fact that the husband owed wife considerable sums.
And that would be an offset.
It would be an offset, although the wife did not file a counterclaim in this particular action, because what it was an
Presumably, the wife has a claim against the estate.
Correct, Your Honor. But in this case, it was simply brought as a complaint for contempt, and that's how it was framed by the parties and accordingly the judge.
So it's interesting. When in relation to Smith against Smith was the complaint filed? Because I have a little knowledge about this, as you may understand.
Yes, I saw that, Your Honor.
The bifurcation between the complaint for contempt and whether the money is still owed exists actually, Wooters, as my memory actually, it's reflected there. We said it explicitly in Smith, but I would think that if somebody, they have to file a complaint for contempt, right? They need to say, hey, you're not complying with the court's order. And isn't subsumed within that, and the non-compliance, we'd like that to be cured by paying the money.
One concern here is that the trial counsel didn't put in any evidence about the income other than the tax returns. The wife did testify.
That seems to me to be pretty good evidence. Because the tax returns are actually tied to DuPont, right?
Well, they are, and there's a line for that, but what it reflects is what was reported to the taxing authorities. The wife testified that because the son had put a stop to the dividends going into her account, they were no longer directly debited to her account. So she had to report that income because it was under her social.
That's post-2017. There's
Yes.
evidence as to what was paid between 2008 and 2017 before there was any stop put. That's pretty good evidence of what she received, right? Okay.
She's not disputing.
The judge does say that the court did not receive evidence of the amount of dividends paid to defendant during the time frame when payments were ceased by act of the wife's son or the special representative. And so that's talking of, she's referring only to after 2017? Post-2017.
My understanding is that piece is the 217, for which she testified she did not actually receive the dividends for that year and the years thereafter.
All right. Okay. Any more questions? Any more questions? The panel has no further questions, but you still have some time. You're not obligated to use it. Is there anything else you want to bring to our attention?
Just a few brief points, if I may. So the case law, I would dispute counsel's interpretation of the case law. There does appear to be a thread of some level of intention. The Wooters case even uses the word good faith, and I think the trial judge here did find that the wife had acted in good faith, and she was well within her discretion to find that the judge had perfected the transaction to the best of her ability. The standards also, of course, are that the petitioner was required to show more than a preponderance. It was clear and convincing evidence. The standard is fairly high. And any ambiguity in the order was to be construed in favor of the wife under Wooters. Wow. Another case that I just wanted to point out, I think that there is case law that says that reliance on counsel is significant. The Alves versus Braintree case did find that because the alleged contemptor had relied on advice of counsel, that was sufficient or to show good faith and to avoid a finding of contempt. And if the court does not have any further questions, I'd rest on the brief.
Did their request for contempt, do you recall whether it contained a request for the money?
The complaint simply asked for a contempt finding based on never transferring the investment account and for failing to transfer the dividend streams and for marital property, which claim was dismissed. There was no specific request.
Failing to transfer the income streams.
It was a mistake that the counsel called it an investment account. It was actually just shares.
Okay. Well, thank you both very much. Thank you. The case under advisement. So we're finished with our hearing today. The court will stand in recess.
All rise.